Welcome to the West Virginia Supreme Court on the West Virginia Channel. I'm Beth Voorhees. Today, the Supreme Court justices will hear oral arguments in the case of the head of the Democratic Party versus Governor Earl Ray Tomblin, involving a vacant seat in the West Virginia Senate. Former Wyoming County Senator Daniel Hall was elected a Democrat in 2012 and turned Republican after the 2014 elections, breaking a tie for an 18-16 GOP majority. Hall resigned earlier this month. State law is ambiguous about replacing someone who has switched parties. A Democratic appointment would deadlock the Senate 17-17. The justices hearing the case are Chief Justice Menace Ketchum, Justice Robin Jean Davis, Justice Margaret Workman, Justice Alan Lawfrey. Justice Brent Benjamin recused himself from the case, and Chief Justice Ketchum has not named another judge to replace him. Petitioners Belinda Beafor will be represented by Anthony Magistro. Governor Tomblin's attorneys represented by Peter Markham. We take you live now to the West Virginia Supreme Court of Appeals on the West Virginia Channel.
Have a seat. For the lawyers, we've all read the briefs, we've all studied it, and we've studied everything that's been submitted. I know we're on TV and people like to talk, but don't regurgitate just what's in your brief. We've read them. Try and get to the point. Mr. Magistro.
Mr. Perry, if I could, I would like to reserve 6 minutes for rebuttal. Mr. Chief Justice, and may it please the Court, I'm Anthony Magistro, and I'm here on behalf of the Democratic Party petitioners because the issue in this case is whether our election laws are to be interpreted to honor the mandate of the voters or the self-interested decision of a politician. West Virginia Code Section 310.5a provides that when a vacancy in the Senate occurs after a legislature changes political parties, that statute should be interpreted to mandate that the governor fill the vacancy from a list submitted by the party executive committee of the party with which the person holding the office was affiliated at the time of that person's election. This is an important provision in our election law, and the only purpose for this provision is to serve the purpose of respecting the mandate of the voters as best as possible when the person they elected to a 4-year term resigns or is otherwise unable to complete his term.
Then why did you focus only one paragraph of your petition on the constitutionality of this statute?
Because we believe that our interpretation of the Constitution, of the statute, allows the court to avoid constitutional questions. And as this court has in a number of cases said, if there are two interpretations of a statute, one of which causes the statute to be unconstitutional, one of which allows the statute to...
Not two interpretations of the statute. You have to address the constitutionality of it. Did you bother to read Rodriguez versus Puerto Rico?
Yes.
The United States Supreme Court case?
Yes, ma'am.
That turned on a constitutional question.
And in that case, the court...
Yes, I don't think you even cited in your petition.
I think we did. In fact, the point we cited it for was the exact argument I just made, is what the court in Rodriguez said was that interpreting the statute in connection with this public policy of preserving the mandate of the voters is a compelling state interest that is one of the reasons they saved the constitutionality of the Puerto Rico statute. And in reference to all of the cases, and we refer, in our argument about avoiding constitutional questions, we refer back to those cases. Every court that's ever decided the purpose for this statute has said that the purpose is to preserve the mandate of the voters. And
you said every court that's decided the purpose of this statute. How many courts have decided the purpose of this statute?
Well, and I probably overspoke. I apologize.
Well, how many courts have decided the purpose of this statute?
This is a statute. There is one statute that is like this statute. It's the West Virginia statute. There's no other statute. But every court that's decided a similar statute has held that the purpose of the statute is to preserve the will of the voters.
Well, I want to go back to Rodriguez again, because in Rodriguez, the court found that there was no constitutional violation because there was no unequal treatment to a different class of voters or political parties.
Right.
That's on page 10 of the opinion. And that the interim appointment, which occurred in Rodriguez, applies uniformly to all legislative vacancies whenever they arise. Now, having found that language in the United States Supreme Court case, does not the statute as written here have a special impact on a discrete group of voters, those being the Democrats? Let me give you an example. Democrats elected, takes office, vacates the office as a Democrat's appointed, correct?
Correct.
In this instance, the Republican Party wants us to accept the doctrine that if a Democrat is elected, switches during the tenure to a Republican, then when he or she vacates that office, a Republican is placed there, correct?
Correct.
So would that interpretation not have a special impact on a discrete group of voters, those being the Democratic Party? Ergo, it would not qualify as equal treatment under the Constitution.
Well, that's obviously the result, and I guess the issue is...
You don't make that argument in your brief.
Well, we make the argument that we don't believe you need to pronounce a constitutional violation because we don't believe that the statute was ever intended to apply in those facts. If you conclude that they're right and the statute's clear, and it's clear right the way they are interpreting it, Rodriguez would definitely be a problem, and we would agree with you that it would be unconstitutional based upon that disparate treatment. However, again, I think one of the points that I'd like to make is to imagine in the abstract a legislature trying to talk about what kind of statute they're going to pass. A legislature that's made up of people who are members of parties. Does anybody really believe that those legislators, after spending all the time and money to get their people elected, are going to intentionally pass a statute that lets the other party poach one of their people and get a seat? I mean, that's what we're talking about here.
That's what the statute looks like it allows on its face. The
Well-
statute is fairly clear on its face. It's difficult to see an ambiguity, and I think that one thing that must be recognized is that this is obviously amongst the members of the legislature and members of others groups that have interest in what the legislature does. This has become a political question, but the court has got to approach it in a non-political matter and strictly in a legal matter in interpreting what the statute says or in moving into a constitutional context, as Justice Davis points out.
And Justice Workman, I think the reason the statute's ambiguous is because, and it's ambiguous, it's not ambiguous most of the time. It's ambiguous because it's applied to these peculiar facts that the legislature didn't consider. And you can really read the statute two ways. As the court in Richards and as the court in Wilson, two courts interpreting not identical but similar statutes come to the conclusion that when you make reference to the party, or you make reference to words like affiliated without specifying the time which that determination is to be made, the statute is capable of being read as either applying to the party at the time of the vacancy or the party at the time of the election. You can read the statute both ways. In fact, the Attorney General, if focusing just on the first sentence of 5A, the one that matters here, it admits in their brief and in their opinion letter that the statute can be read those two different ways. That's the test of ambiguity. And once we get there, once we get to the point where we're looking at grammar rules, at other provisions of the statute, we are down the road into interpretation, not application. And we believe that you ought to look at why this statute exists. And there's only one reason why this statute exists, and that is to to preserve the mandate of the voters as best as possible on these 4-year terms.
Well, on your constitutional argument, which you don't seem to be real interested in making, wouldn't it, if it was unconstitutional for this gentleman who turned from a Democrat to a Republican, if it was unconstitutional with his departure by resignation to place another Republican in there, then wouldn't it have been unconstitutional by the same reasoning to let him sit after he changed parties from the one that elected him?
I think what the case law says on that question is that you have a First Amendment right to be whatever party you want to be. The consequences of that, and the question in this case is, can your decisions have impact on a choice made by the voters, for example? I think if you want to talk constitutionally, one other important point I think is, and why we say the reason the statute is constitutional only if you interpret it this way, is because this court has pretty much said that party matters and party choices are
Well, not
compelling.
only this court, but I go right back to Rodriguez. Rodriguez says that the appointment system in the Rodriguez opinion was constitutional because it served general compelling interests, ensuring stability, continuity of a legislative balance until the next general election, and I think most importantly, protecting the electoral mandate of the previous election. Ergo, Article 2, Section 2 of our West Virginia Constitution, the will of the people.
I don't disagree with anything you just said, Justice
Why
Davis,
didn't you brief it?
because the general hesitancy of courts to rule on constitutional questions when they don't have to. And we truly believe that this statute can be interpreted in a way that makes it constitutional. And I wanted to, with respect to the party, the answer to Justice Workman, the answer to the freedom of association question, this court in Billings versus the city of Point Pleasant addressed that question in the context of a person switching parties prior to registering for election. This court upheld the constitutionality of the 60-day period. You have to make that change 60 days before you file for office. And what that does is that means that you are 6 months ahead of the primary and a year ahead of the general election when you decide you're going to make that change. That is the compelling state interest that this court has even announced without needing to go beyond into federal precedent and constitutional precedent. And again, while Justice Davis, I agree with you, this statute is unconstitutional if you interpret it the way they want it to be interpreted. But we also believe that was never the intent. I mean, if you look at the statutes in this case, across the country, there is no state that has the statute that the Republicans think we have in West Virginia. None. Some states have special elections. Some states have the governor can appoint on their own.
It doesn't mean that the statute doesn't say what it says,
Well,
and that their interpretation of that is just as legitimate as yours.
Well, and we agree you can read the statute two ways. But if you're looking at what a legislature likely intended, which we think you're down that path once you start talking about grammar and looking at other provisions of the code and reading statutes together, all of the things that they bring out to make the statute, to get to the point where the statute's clear, you have to look at the purpose. And every court that's ever decided this issue, every legislature that's ever passed a statute explicitly on this point, and every court that's...
You said that again, though. You said every court that's decided this issue, and I'm going to hold you to that. And now, how many courts have decided that issue with regard to West Virginia statute?
And the issue, what I mean by the issue is the purpose behind these statutes and how you interpret the statute when the statute doesn't answer the question. And the two courts that are most directly on point. Now, granted, they're talking about two different statutes that are different than the West Virginia statute. But what the Kansas Supreme Court said, and
You're going to have to pay for that.
I fixed it. Send me the bill. What the Kansas Supreme Court said and the Wyoming Supreme Court said is that when you just make a reference to the party, because nobody ever thinks that you would try to pass a statute that's like the one the Republicans said, you have to imply the idea that it's the party at the time of the election.
How do you do that from that statute? If you look at the clear language, even the second part of A says the governor shall appoint thereafter a legally qualified person of the same political party as the person vacating the office. How do you interpret that to mean anything other than what it says?
It says the same political party. It does not say the same political party at the time the person was elected.
Exactly. That would have made it much more clear.
Nor does it say at the time the person resigned.
Well, it does over on the
so-
first part of that statute. Party with which the person holding the office immediately preceding the vacancy was affiliated. You've got an uphill battle if you don't move to something constitutional.
Well,
Which is why I keep redirecting you right back to Rodriguez, because
Well,
it answers your question.
I'm not sure there's anything more to say about Rodriguez. I'd be happy to answer questions about Rodriguez if that's what the court wants to do. I'd also
Not if you didn't put it in your brief.
well, we did argue that the statute that interpreting the statute this way created serious constitutional questions, and we referenced. When we sit down, I'll point you to that point. I'll look it up and point you to it in our brief.
Let me ask one quick question, Chief. Sorry. There's been some indication from the Republican side that they may or may not follow this court's directive. How will the Democrats react depending on how this court comes down?
Well, I think that's probably a better question for the Governor's Council, but on behalf of the party, we respect the decisions of this court. I think the Attorney General respects the decisions of this court. We have a situation where the Attorney General asked this court to stay the governor from appointing, so obviously they believe you have the power to do that. The governor's followed that in good faith, and I think in behalf of the Democrats, we would always respect the decisions of this court in interpreting statutes, and I think there's plenty of precedent that makes that okay. I mean, back to Powell versus McCormick, United States Supreme Court, where the same kind of issue came up, where the one party in control refused to seat a member of the House on grounds that weren't in the Constitution, and the Supreme Court said, we get to tell you what qualifications mean and what the statute means. Your power to determine who you seat doesn't extend to ignoring our pronouncements, and we believe. I don't know. There's a lot of political talk going on. I think it would be unfortunate if the Senate would refuse to follow this court's mandate.
Thank you. Mr. Markham?
Your Honors, may it please the Court, my name is Peter Markham, and I represent Governor Earl Ray Tomblin. The Governor's position has not changed. It honors the will of the voters. This Court should authorize Governor Tomblin to pick from the Democratic list. And I've got a roadmap for how you can get there without even addressing the constitutional issues that you seem concerned about. That roadmap is the Wilson.
I'm concerned about them.
All right.
I don't want to speak for my colleagues.
Well, the Wilson and Richards cases give you the roadmap for resolving this controversy without having to address the constitutional problems.
That's assuming the statute is ambiguous.
Correct. And I would
Not.
submit, may I explain the 4 reasons why I believe the statute is ambiguous? First reason is, if you look at the first sentence, which is Governor Tomlin's charge, the only sentence that matters, it fails to specify when party affiliation is relevant. Is it at the time of election, or is it at the time of vacancy? The interveners concede this point in the middle of their brief on page 9, and I quote, the phrase was affiliated might be understood in one of 2 ways, to refer to the senator's party affiliation at the time of election or appointment, or to the senator's party affiliation at the time of vacancy, end quote.
Well, let me ask you, Mr. Markham, Mr. Markham, are we bound by anything that the Attorney General's office says on that?
I would say no, for the same reason that I didn't take much, we did not honor the Attorney General's opinion. And the reason we didn't honor it is I thought the opinion gave short shrift to the 2 out-of-state cases that I thought were right on point and would give this court better guidance.
Well, assuming that your argument's correct that the first part of the statute is unclear, what about the last sentence of Part A
Sure.
that talks about a legally qualified person of the same political party as the person vacating the office?
Right.
How do you get around that one?
Using that sentence to interpret the first sentence just highlights the first sentence's ambiguity, and the first sentence is the one that matters. That sentence, the one that you're referring to, only comes into play if no list is submitted to the governor. So I would suggest that that sentence isn't even relevant. The legislature also uses the phrase person vacating office in that last sentence. It could have used that phrase in the first sentence, which is Governor Tomlin's charge. It didn't. I think that is important, and I think that's relevant. Another reason why this statute is ambiguous, and this is going back to the first sentence, you look at the immediately preceding language. As the briefs show, I've got to look at my notes here, the petitioners believe that that language identifies the person, the office holder that just vacated office, whereas the respondents take the tack that immediately preceding relates to time of party affiliation.
Well, look at it either way. He was still a Republican under either interpretation, wasn't he?
No, he was affiliated with both parties. He was elected as a Democrat. He ran as a Democrat. The voters elected him, and he served the majority of his term of office as a Democrat. So I would submit that he was affiliated with both parties for purposes of that statute. Where the ambiguity comes into play is an as-applied reading of this statute. And the best way to show that is the Richards case. It has some great language. It says the statute at issue, and that's I believe it was the Wyoming statute, does not address or anticipate the situation presented in this case. That's what we have here. Our West Virginia statute doesn't anticipate a party swap. Because of that fact, we've got to look at the point of the statute, and the point of the statute is to honor the mandate of the voters. Therefore, I would suggest that this court should honor the voters of the 9th District and hold that in party swap circumstances, party affiliation at the time of election controls. That squares with this court's holding in Billings. That's the Justice Cleckley opinion, where he recognized the state of West Virginia has a compelling state interest in ensuring the integrity of the political process and preventing party raiding. The last point I want to make is that the position advanced by the respondents could lead to an absurd result. The absurd result being the very individual that appears on the list that the respondents submitted to Governor Tomlin is the person that Daniel Hall beat as a Democrat in 2012. So you could have the weird situation that Governor Tomlin could be forced to pick from a list that contains the loser. That's not fair to the voters of the 9th District, and for that reason, the writ should be granted, and Governor Tomlin will, of course, abide by.
And I appreciate that, Mr. Markham. And why will the governor abide by what this court does?
Well, I go back to the first case I read in law school, Marbury versus Madison. It is emphatically the province of the judiciary to say what the law is. We will respect that.
And I appreciate that.
Mr. Atkins?
Thank you, Your Honor. Chief Justice. May it please the court, Chief Justice, members of this court, my name is Mark Adkins, and I have the honor to represent the respondents Beverly Lund, Justin Arvin, Naomi Sue Klein, and Tony Painter in their capacity as members of the West Virginia Republican Executive Committee for the 9th Senatorial District. With respect to West Virginia Code 3-10-5A, it is my client's position that this statute is clear and unambiguous on its face.
Let's assume it is. Then how does it withstand the constitutional requirements set forth in 1982 by Rodriguez versus Puerto Rico?
As the Rodriguez court pointed out, it found that no provision of the federal constitution expressly mandates the procedure that a state or a Commonwealth of Puerto Rico, in that instance, must follow in filling vacancies in its own legislature. And here, the legislature has created, by enacting this statute, a means in which if there is a vacancy in the legislature, that legislative district will not be unrepresented in the legislature, and it will be not just a certain political party, but all voters in that legislative district will be represented in the legislature. It went on to state that in the instance of an appointment, while the choice to fill legislative vacancies by appointment rather than a full-scale special election, as some statutes require in other states, as well as some statutes in West Virginia, that would have some effect on the rights of citizens to elect the members of the legislature. However, that effect is minimal. And certainly, this appointment process, which the legislature has enacted with this statute, does not prevent the will of those voters from being expressed. Again, this appointment process spelled out.
Well, it certainly does. I would suggest to you that is an unequal treatment to different voters because there is a special impact on a discrete group of voters. In this instance, the Democrats who voted Mr. Hall in then do not get the same result as if he goes in as a Democrat, switches to a Republican, and then a Republican is appointed. You get two different impacts in interpreting the same statute. I don't think that meets the constitutional requirements set out in Rodriguez.
Well, with respect to that issue, Justice Davis, in this instance, it's our position that the 9th District did not elect a party or a party designee. They elected a person that they felt comfortable. And not to say that Senator Hall was elected solely by Democrats in 2002. There could have been Republicans that voted for him as well, just as there might have been Democrats that might have voted for his Republican opponent. But the majority of the electorate in the 9th District voted and elected Senator Hall to represent not just the Democratic Party, but to represent all the constituents. And based upon that election, they entrusted Senator Hall to represent them in the legislature, in the West Virginia Senate, to make decisions and make votes on their behalf. And one decision was to best represent their interest, and as Senator Hall explained when he switched parties, he felt that his switching party, which is his right under the First and 14th Amendment of the U.S. Constitution, was the best way to represent his constituents, not just a particular party, but all of his constituents. And that's what he did, and until the time that he vacated office. And so back to, and with respect, though, to unambiguity of this, the important factor with respect to this statute, which makes the arguments of the petitioner, as well as the respondent to Governor Tomlin, that there is some ambiguity. This statute lays out a specific term that identifies a specific period of time in which the governor must examine the party affiliation of the vacating legislator. And that is immediately preceding the vacancy. In both the Wilson and Richard cases, neither of the statutes referenced in those opinions identified a specific point in time. Other statutes, as Petitioner's Counsel referenced, do identify a specific point of time in other states, that specific time being at the time of the election. Whereas, and that's what he is asking this court to infer into this statute. However, to infer that, one, is inappropriate under the canons of statutory construction, but it's also asking you to omit the language immediately preceding the vacancy. The legislature in 1963, when it included that language immediately preceding the vacancy, did take into account the possibility that there could possibly be change in party affiliation. by the very nature that they didn't leave it silent. They did identify there's a specific point in time that the governor must look at with respect to the vacating legislators' party affiliation, immediately preceding.
Well, I'm going to go right back to Rodriguez again, because the Rodriguez court held that there was no unequal treatment because the interim appointment applies uniformly to all legislative vacancies whenever they arise. In your situation, the way the statute is written requires different results at different times when the vacancy arises. So you tell me how that meets the constitutional requirements set out in Rodriguez.
Again, Your Honor, I think it focuses on the fact that we, the citizens of West Virginia, in this instance specifically citizens in the 9th District, elected a person and not a party. And again, it wasn't based solely on a party designee. People from various different political parties could have voted for Senator Hall. And they put their trust in him to make the decisions and make votes. He's not required to vote along the party lines in every vote that he faced within the West Virginia Senate. And part of that decision to best represent his constituents included his constitutional right to change party affiliation in order to best represent.
Nobody's
the
debating
voters.
that. He has the absolute right to do that.
But again, the argument made by the petitioner is they're not saying that there shouldn't be a specific period, or there is no specific period of time. They just don't like the specific period of time outlined in the statute. They want to look back at the election. However, the argument could also be made that the time of the election isn't the appropriate time. In this instance,
One of the very reasons that the Rodriguez decision was upheld was because it provided consistency, continuity, stability, and protecting the electoral mandate of the previous election. That's on page 8 of the opinion.
thank you, Your Honor. And Your Honor, I think that what my clients are proposing here accomplishes that because, again, it is set out by the legislature. The legislature has chosen that any vacancy in the legislature is to be filled by appointment, not by special election. And that any imposition, and as the Rodriguez Court pointed out, any imposition on the voters by appointment is minimal because it is having a special election, going through that inconvenience and costly expense of a special election is not as important. That effect on the voter, the mandated voter, is minimal. It's outweighed by the importance of making sure that the constituents of all parties are represented when there is a vacancy in the legislature.
Well, in Rodriguez, they didn't let all the parties vote. The party that Mr. Manny or Monty was in was the Popular Democratic Party, and those were the only people that were allowed to make the appointment. There was not a bipartisan election from all the different parties in Rodriguez. Am I wrong about that?
No, Your Honor, you're not. But again, I believe that in this instance, the mandate of the voter is protected because, again, the voters have entrusted Senator Hall to make the right decisions on their behalf. And he has done so. And one of those decisions was in order to best represent his constituents, was to change his party affiliation, which he did. And as a result, this legislature has identified a specific point in time. And I think it's important to note, Your Honor, that this language in this statute has been in place since 1963 without incident, without challenge to the court.
It's actually been in place longer than that.
You are absolutely correct, Justice. But with respect to the language immediately preceding the vacancy, at least on my research, and if I'm wrong, I apologize, but based on my research, that was the first inclusion of the
Well,
statute.
Mickey's may be a little wrong. It goes back to around 1931.
And I certainly would trust your research better than mine, Justice.
But let me ask that same question before you sit down. What would your advice be to anyone? How do you think that the Senate should proceed regardless of how this court comes down with its opinion?
And Justice, I appreciate that question. However, I don't represent President
But
Coley.
I'm asking you. You're an
Certainly,
officer of the court. What do you think?
Your
What
Honor,
would you advise a client?
Your Honor, I certainly advise my clients to respect the authority of the court in all instances.
Thank you, sir.
Thank you.
Mr. Solicitor General.
Mr. Chief Justice, may it please the court, Albert Lynn, I'm here on behalf of the Attorney General. Justice Davis, I would like to address your constitutional question, but if I may very briefly address the ambiguity or lack of ambiguity in the statute. Our position, as has been, which is similar to the respondent's position, is that we think the statute is clear, and I don't think we have heard today any argument that plausibly makes the case that the statute is ambiguous.
But that's not exactly what you say in your brief. You say it could be considered ambiguous. So is it or is it not?
Your Honor, what we say in the brief is that we think what we refer to as the first sentence in subsection A, which is the operative sentence here, is not ambiguous. We acknowledge that taken in isolation, the phrase was affiliated could have other conceivable readings, and that's what we say.
Well, if that's your position, Mr. Lynn, then why would we not follow the analysis set out in the Wyoming and the Kansas opinions simply for public policy reasons, and then with regard to Article 2, Section 2 of our Constitution, to fulfill the mandate of the voters of the state of West Virginia?
Justice Davis, the response to that question is that this court has made very clear that statutes are to be read in their entirety. So first, we do not believe that that sentence is ambiguous. We acknowledge that there are other conceivable readings, but of course, multiple conceivable readings do not make a statute ambiguous. There must be multiple reasonable readings. And with respect to that question of reading the statute and that sentence in context, I would respectfully disagree with my friend, Mr. Markham. The other sentences are relevant. The last sentence that Justice Workman referred to in subsection A, which puts a limitation on what the governor may do in the instance where a list is not submitted. It says, he shall appoint a legally qualified individual of the same political party as the person vacating the office. The use of the present participle is indisputably clear. We have given a number of examples of the same construction, and I can give more today. The color of the hair of the person crossing the street, the age of the person celebrating a birthday. In all of those instances, the antecedent characteristic is changeable. What is the color of the hair? What is the age of the person? And there is no question in any of those sentences, in any of those phrases, the time at which you identify the antecedent characteristic. So we think that that sentence, that last sentence of subsection A is clear. It is a reference to the party of the vacating senator at the time he or she is vacating the office. And if you were to accept Mr. Markham's attempt to segregate that sentence and read them in isolation, you would end up with what is clearly an absurd result. It would be a situation where if a list is submitted in this particular case, it will be submitted under his reading by the Democratic Party. But if a list were not submitted, the governor would be required to appoint someone from the Republican Party. There is no reasonable way that that makes any sense. And then, of course, the subsection 5C, which we discussed in our brief, has not been discussed today, specifically uses the phrase, the time of the election or appointment. And under this court and the longstanding precedents of all courts, the legislature's specific use of that phrase there must be taken to mean that you cannot import it into the operative sentence in subsection 5A. But if I may, let me turn to the constitutional issue.
Now, I want you to answer my question also, the same one that I've asked everybody else.
Of course, if you would like, I'll turn to that first. As to the question of the Senate qualification power, and I'm not trying to duck your question, but what I can say is we have not looked at that question. The Attorney General's office does not have a position at this time.
Is it really a hard question? Is it that hard? If a court comes down and decides the case in one direction, does a party have to follow the court? Is it really any more complicated than that?
Your Honor, I cannot take a position on that at this time. We have not looked into our view of the scope of the qualification power, and so I will be...
I'm disappointed in you, Mr. Lynn.
I apologize, Your Honor, but at this time I cannot take a position for the Attorney General's office, just on the scope of that power. But to get to the constitutional question, Justice Davis, I think the first thing to remember is, and I think it has been stated already today, if there are not...
But what if a court finds somebody in contempt for not following its order? Then what do you think the court's actions can be?
Well, if in the ordinary case where you're dealing with an order of the court, of course, it is binding on the individuals before that court, and that this court can find somebody in contempt for not following the order. The question here is, what is the scope of the Senate's qualification power under the Constitution of West Virginia? And we just don't have a position on the meaning of that qualification power at this time. As to Justice Davis's constitutional question, the first response, of course, is if there is only one reasonable reading, you cannot invoke the doctrine of constitutional avoidance. You have to get squarely to the question of the constitutionality of the statute. You are, of course, exactly right, Justice Davis. And so the first answer to your question is they have waived the argument. They did not make the argument that it is unconstitutional. This court has...
He fed one paragraph at the end of his petition about the constitutionality of it. Did he go into any analysis? No. But it's there.
Fair enough.
Nobody else did either.
Right. Well, we don't think that there is a constitutional problem. And so, Justice Davis, what you have put your finger on is you've said, well, there will be a group of...
Rodriguez decided the case, the most recent United States Supreme Court case that I can find, 1982, 30-some years ago, addressed the question squarely on the constitutionality of the statute. Yet you guys avoided it like the plague in your briefs.
Well, he did not raise it specifically, and we did not see a reason to respond to it. But the response is this. Justice Davis, you have suggested that there is a special group of people, a small quantity of people who will be specially affected, and those people are the Democratic people who voted for Daniel Hall because he was a member of the Democratic Party.
I'm suggesting it. I'm just following the language on page 10 of Rodriguez that says there was no unequal treatment violation of the Constitution because the interim appointment applied uniformly to all legislative vacancies whenever they arise. In this situation, you all want us to apply it to a specific time when the vacancy occurs, and I think, I don't have the footnote in front of me, but that is one of the reasons that Rodriguez said that if there is a special impact on a discrete group of voters, it will not comply with the equal treatment.
Your Honor, if I may, here's my response to your question. Under their reading of the statute, there is also a group of voters who will be affected specially in different circumstances. That group of voters is the group of voters who voted for Daniel Hall and to trust his judgment as to what the party affiliation would be. If we take a step back and just sort of think about the voters that we're talking about, they would have voted for Daniel Hall for a number of different reasons. There's a group of voters who, we don't dispute this, probably voted for Daniel Hall because he had a D next to his name in 2012. However, there is also a group of voters, and I don't think this can be disputed, who voted for him because they trusted his judgment, and they voted for him to represent him as their agent and to do what he thought was in his best judgment was best for the interests of the 9th Senatorial District.
What's
Those
the-
voters...
What's the compelling state interest in that argument if it circumvents the mandate of the people?
Well, those voters would be treated differently under their reading of the statute. If Daniel Hall switched parties and we required the party affiliation to be determined at the time of the election, that group of voters, however small they might be, would be treated differently. They would have to, under the situation where he doesn't switch parties, they wouldn't be especially affected. But if he does switch parties, their will and trust in Daniel Hall would be thwarted because they trusted his judgment, and if he thought it was best for their interest to switch to the Republican Party, we would be, under this reading of the statute, requiring a Democratic Party appointment. So, Your Honor, the answer to your question is because there are different groups of voters who voted for Daniel Hall for different reasons, under both readings of the statute, there would be a group that is treated differently in different circumstances. And the other thing that I want to make sure I say is, there has been a suggestion that under the clear reading of the statute that there will be absurd results or there will be a constitutional problem because the person or a person defeated at the election could be appointed to the office. That very same scenario could happen and has happened in the last 5 days under their reading of the statute. And that's on Friday, Governor Tomlin appointed Bill Flanagan to replace Amanda Pasden in the 51st House District. Bill Flanagan is a Republican, as was Amanda Pasden. Bill Flanagan finished 9th in the multi-member district election in 2014.
Well, that's not an issue. I mean, the governor can appoint whoever the governor appoints.
But my point is that the argument that someone who actually lost the election could be appointed to that office
It doesn't matter.
occurs under both readings of the statute. And so I don't think that that is a thumb on the scale either way. At the end of the day, I think what this case comes down to is the statute clear as to the question presented? We think it is, and on those grounds we ask that the petition be denied. This court made clear that the governor's obligation is to appoint from a list submitted by the party at the time of the vacancy.
Well, let me ask you, so if you don't take a position on whether the Senate would have to follow us, would the governor have to follow us? Or
Well,
does anybody have to follow a court order?
People do have to follow a court order in the ordinary circumstance. Again, Justice Lawfrey, the only question that we are not prepared to answer today, because it is not before this court at this time, is the scope of the Senate's constitutional qualification power. The governor does not have that same power, and that's the difference between the two bodies. Thank you, Your Honor.
I want to respond to his response on the constitutional argument. First,
Well, you should have put it in your brief.
well, that's the first response, and that is, we've made the argument that you should interpret the statute to avoid these serious constitutional questions, as reflected by the other courts who've decided that issue in reference back to the footnotes that are on page 21 to footnote 29 in the brief with five cases where that issue is discussed, starting with Rodriguez. I think, I'd love to be able to read your all's minds as to what you think the best arguments are before I write my briefs. But I think the thinking was that we would give you the least complicated way to get a final decision on this question, rather than having to interpret the Constitution. We believe the statute's not constitutional interpreted the way they did. And to his response to this is that there's this group of people who voted for Daniel Hall who might have their will thwarted. And the answer to that is there's a compelling state interest to interpret the statute our way, because interpreting the statute our way goes with the will of the majority of the voters. And that's what Rodriguez talks about. That is the compelling state interest. Interpreting the statute in favor of this minority group who voted just to trust Daniel Hall is supposedly, there's no compelling state interest in that when you are going against the will of the voters and the mandate of the voters. I think it's important to point out that, we can speculate why Daniel Hall got elected, but we do know that one time he ran as a Republican, he lost. And
What's your point?
that the voters elected a Democrat. Daniel Hall was a Democrat. They elected a Democrat to a 4-year term. That is the only concrete knowledge we know of what the will of the voters was. And he had that First Amendment right to switch, and he could have vindicated his decision this November had he chose to, but he didn't. I mean, that's why that's the answer to this is if you think you're the right way, the voters will let you know in November. He didn't give us that opportunity, so now on this 4-year term, and I think it's important to understand what we're talking about. There's a reason Senate terms are 4 years, because we want them to be more stable than House terms. That's why we don't think it's appropriate to look at what happened in the 2014 election or what the voter registration is now or any of those changes. It's the whole idea that we elect senators to 4-year terms, so we freeze in a certain stability into the system. That's why the Senate exists. I want to say one thing about ambiguity, and again, when you have to go to rules of grammar, which this court said in Davis Memorial aren't binding, they're just informative, to make the statute clear, the statute's ambiguous. They say the first clause, the Attorney General agrees, this statute, we believe, is susceptible to multiple meanings. All of their arguments for how you get it clear are under the guise of trying to make it clear, but in reality are just tools of statutory interpretation. Once you open the toolbox, we think in this case you ought to get the most important tools, and that is interpreting the statute consistent with their policies, interpreting the statutes to avoid absurd results, and interpreting the statutes to avoid multiple constitutional questions, not just the one in Rodriguez. Finally, this whole idea that we elected the individual, not the party, the statute is the one that says, the statute explicitly says, the party committee picks. This isn't a question of whether the individual picks or the party committee picks. It's a question of who gets to decide which party committee picks. And we believe, like every state that has come up with a scheme similar to West Virginians, that the answer is the party committee from which the person elected was affiliated at the time of the election. That's what supports public policy. That's what supports constitutionality. It's what supports common sense. No legislature would ever pass a statute they think we did. Unless the court has any other questions, I'll just ask the court to grant the writ and order the respondent to appoint from one of the 3 listed in the list provided by my clients.
Have a seat. Marshall?
You've been tuned to oral arguments before the West Virginia Supreme Court on the West Virginia Channel. We'll have to wait for the court to decide if a Republican or a Democrat will be named to a vacant seat in the state Senate. Does the party have to follow the court? We heard that question often from the justices to the attorneys. This goes to reports that if a Democrat is named, the Republican leadership in the Senate has said that they may not qualify that appointee, therefore not following the High Court's decision in the matter. We will all wait for the court to decide which party gets the vacant seat in the state Senate. This concludes today's broadcast from the West Virginia Supreme Court on the West Virginia Channel. This program reminder, the Legislature Today, our nightly broadcast of legislative news and information, airs at 6:30 and 11:30 every weeknight on West Virginia PBS. The Legislature Today will be repeated weeknights at 10 and weekday mornings at 6:30 right here on the West Virginia Channel. Tonight's program will feature today's arguments before the state Supreme Court. I'm Beth Voorhees for the West Virginia Channel, a service of West Virginia Public Broadcasting.